let me see if he can arrange the, but it is that time certified copy would not be.
No need of certified copy. You can
Because
get
he
hold-
says that whoever has given me the writ, actually he has not, the LPA, he has not given me the
Mr.
copy of the writ.
You
Anyway,
are-
should I argue the case? Should I say the merit, submit the merit of the
Be
case?
absolutely satisfied about what you have to argue and then argue.
I am
please-
actually, I need the copy of
Yes,
the.
we have heard that. You need not
But
repeat
I-
it all over again.
He says that you argue on the LPA.
All right.
Okay, I have got it.
Yes.
See, in this case, what has happened is, there is one college.
Yes.
Its name is National Teachers Training College. It is in Khajanchi Road, Patna.
Yes.
It is in Khajanchi Road, Patna. Now they offer degree of B.Ed, Bachelor of Education. Now they intends to run a course of DLA,
DLED.
Diploma in Elementary Education, DLED. They said DLED. This course has very recently come, and they said that we would run this course. Now, if you want to run this course as DLED, then you have to have a recognition from NCTE, that is National Council of Teachers
That's all right.
Education,
You proceed
which
ahead,
is
please.
there in Bhubaneswar.
Yes.
Now, accordingly, he is applied. He has submitted a fee of 1.25 lakhs, and whatever necessary document they wanted, he has submitted. Now, what happened on 22/12/2016? They demanded few more papers. What papers? They wanted the approved plan of the PRDA of the building what is getting constructed there in the Khajanchi Road. They wanted no objection certificate of the Patliputra University to which this institute is affiliated, and they wanted the fee structure to be given in chart, that 1.25 lakhs, how have you submitted? Now these three papers actually they wanted, NTC. Now the problem is that all of a sudden the father expired of the petitioner, and the son has also expired. He had some problem expiring in the family. So what he did is, on 19/5/2015, he applied for postponement of date, that you give me another date so that I appear, I bring this paper and submit everything. But instead of, Lordship, am I?
Yeah, we are hearing you.
Lordship. Now the thing is that instead of postponing the date, the
They close the
committee,
file altogether.
Lordship,
They close the file.
they closed the
altogether.
file. They said, no, we will not postpone. We have simply closed the file. Now, against the closer,
We have followed them.
Lordship, against the closer, they went to the appeal.
We are
Appeal what they have.
We are skipping that part. Now hear the court first. We are skipping that part of the order,
Yeah.
that part of the development.
Yeah. Now,
Just a minute.
Lord.
Your application for recognition was rejected.
they closed the file, naturally rejected.
You filed a statutory appeal.
Appeal.
That also was rejected.
Yes, on the same grounds what they have taken.
And you say that you could not pursue the first application and the appeal because of sudden deaths in your family. Series of deaths, all right?
We.
Now the court has been cautious. The court says that you apply afresh. Now assuming but not admitting the fact that this order, we don't find any fault lines in the order, but suppose we do away with this order, your recognition would be from a prospective date, not from the retrospective date. Is that okay? Is that proposition right? Now in that event, try and understand what the court is saying. Don't just remain stuck to your ground which you've prepared.
Aye.
Right? So therefore, this order does not affect you adversely at all. Have you followed why?
I am following,
Those
Lordship.
are, even if we set aside the order or we direct the ERC, NCTE, ERC at Bhubaneswar, to decide your matter and not take it as a closed file at your instance, and if they decide to give you recognition, that would be from a prospective date. All right? So therefore, you would be well advised to file a fresh application for recognition, which they would be under an obligation to see
Lordship,
and decide.
Why
Should we interfere with this order?
Lord, am I allowed to speak something
Yeah,
to
please,
argue, submit something?
It's your case.
Otherwise,
yes.
otherwise Lordship said, do not interfere when I am arguing, when I am putting my time. The thing is that I have deposited a fee of 1.25 lakhs. I have deposited the no objection certificate they wanted.
Mr.
Now,
Singh,
Lordship.
Just a minute. You need not, when the court is asking
Lordship,
question,
one more submission.
please.
Oh.
Mr. Singh, would it be okay if we direct that the amount which is deposited deposited shall be adjusted in the fresh application.
Lord, clause 5 of the regulation 2014 says that once the rejection is made, the fee is forfeited. He has to apply afresh.
So he loses his 1,25,000 and the
Because Lord,
possibility of
the
recognition.
institution is closed for more than 5 years.
Oh.
It was rejected in 2016, and in January 2017, he gave a petition to close the file. They are not mentally prepared to conduct an inspection.
That's all right. He says that it was only for.
And in paragraph 10, Honorable Single Judge has given this liberty to
We have
him.
seen that. We have seen that, therefore we have confronted
In
him
paragraph
with that.
10, he says that he can, accordance with if legally permissible.
Yes, I forgot your name, Mr. Counsel.
My name is Ravi Shankar Ganguly.
Mr. Ganguly, now we were.
I was sick actually, only your lordship has allowed me to go to AIMS and come back.
All right. So, Mr. Ganguly, we were contemplating that if it was acceptable to the NCTE, we would have asked them to adjust this amount of 1,25,000 in the fresh application which you have filed, which you would have filed for your recognition. But as he says, the amount is forfeited with the closure of the file. Now 5 years have passed by, we may not be legally, correct in directing him to adjust the amount. So that amount you have lost.
Lordship, should I say something? With the permission of the Honorable Court, I have got two submissions. The first submission is that they say, we are continuously in interaction with them. They say that if the court says that you adjust this amount, then we will adjust. Number one.
This is what.
Now what he says is correct. What he says in clause 5.
Without your argument, did I not ask this question from the NCT
Lordship,
lawyer?
Lordship.
Then?
Lordship, I am coming to the point only. Lordship has beautifully come with the conclusion that if we say that you adjust, then they have to adjust. Number one. Number two is that the great difficulty what we are facing right now is that the portal what is there is not being opened. The portal is constantly, I found that is closed. And they will not open the portal because the case is closed.
That point I must say,
the
government of India has taken a policy decision that it is a pan-India policy, my lord, that the portal has been closed. It is expected to be open in near future, my lord.
Why you are not allowing any?
From 2019, Lord, we are not allowing any further recognition.
As this decision got something to do with the corona?
No, my lord. It is the policy now, Lord, in new education.
Policy has to be, there has to be some basis for.
Now, new education policy, they are going to introduce a 4 years integrated course. And in this year, my lord, they are going to initiate.
Otherwise also. So they will come up with new plan, new fee structure, new amount. So therefore that is lost.
Lord, now that advertisement has already come for 4 years, although it is for 50 pilot project they are going to start, Government of India, across the country. So at present it is closed, but I expect not in near future it will open.
Yes.
What he says is to extent is correct. In clause 5 it is written that it is forfeited, but with the order of the court, this court has enormous power. The court can do it. Number one. जैसे हम लोग सुंदरकांड पढ़ने से पहले किचकिंदा कांड पढ़ते हैं, so that कि सुंदरकांड में आपको इतना पावर है. We read Kichkinda Kand and then we'll go for the Sutkanda. So what I am doing is I am reading Kichkinda Kand. This court under Article 226 had got enormous powers. The clause 5 gone under Kichkinda Kand. Now coming to the point is that the court has beautifully come to a conclusion, and I am also I have to agree, and I agree. Let there be a direction to adjust the fee, open the portal, and if it is not possible, then let there be a fresh inspection. I am ready for the inspection now. If there is an inspection and they pass an order, and if it is not in my favor, I will come to the court, and if it is in my favor, I will be happy, I will be very much obliged to the court. So I seek a direction of this honorable court to give a direction to them to inspect my organization, because I have got an approved plan, I have got 2000 all NOC certificate, everything. Inspect, pass an order, and if I find that yes, it is acceptable to me, I'll accept. I will find it is against me, I'll come to the court.
That's Mr. Ganguly, that is not possible now. we would have been happiest to do that, to order that, but it is not possible because now it is closed. Now any institution which has to open and which has to have the recognition of NCTE has to have the infrastructure and model for 4-year integrated course. Now this 2-year DLED course is over.
That is why what Lordship is of opinion, I admit the opinion of the Lordship is a very fine opinion that new course is coming. Now let them inspect and give me a perspective, and I will take the admission of the new students. And if the students are there with me, I will say immediately, now 4th year's degree course if they say, but that has not come to us. No such notification has come to us. So let there be a direction, Lordship,
Mr.
to
Ganguly,
inspect and pass a fresh order.
We are sorry, we can't help it, that notwithstanding the fact that there were some mishaps in your family, and we were trying to soft pedal the issue. We could have asked the NCTE to have adjusted the amount, but with the forfeiture of the fee because of closure of all such process and new education policy, new system of elementary education on the anvil. I'm sorry, we can't.
Let me give. If it is posted for another week time, I will give some beautiful ruling of the Honorable Supreme Court. Now the Supreme Court in many cases has said that if it has passed, Lordship, with the kind permission, if I am allowed to speak 1 or 2 words for my satisfaction. Now the thing is that I have deposited a fee of 1.25 lakhs that your Lordship has. I have invested a lot to construct this institute. I have invested about 8 crores by taking loan from the bank. Now everything is riding on my head. I have given a heavy installment. I seek only one direction of the Honorable, one direction, that let there be a fresh inspection and pass an order. And if that order is against us, we will come.
That scope
but
is
not by his submission that please close.
No, that scope is closed now.
Could the court, the court has enormous power. The court has enormous power. Our subclause 5 does not stand before clause 5. The court has got enormous power to say that inspect afresh, pass a fresh order, and if you find that it is not as per your terms, you pass a fresh order. But till such time it is inspected, how can they pass an order? Now I would also submit 2-3 things. Here they say, in the appeal what they say, that you have not given a proper PRDA plan. This is wrong. In PRDA, actually in Bihar, PRDA actually did not give certificate. It is the certified engineer who gives the certificate. In Odisha, the systems are different. Anyway, but that dispute could also be over. If there is an inspection, PRDA people will go and say that yes, we give through the certified engineers, everything will be done. So I humbly submit, very humbly submit, to pass a direction for a fresh inspection and pass an order, so that I get the recognition, and the students who have already, I have taken admission they could also get a recognized
that if you have taken admission, you have committed a fault.
No, we have never assured that we will give you a certified degree. We will say that we will educate.
Don't make that statement before the court. That goes against you.
Yes.
You cannot take admission.
I cannot take admission for this course. I can only say that this is the syllabus we can teach you. But we cannot give you a certificate of recognized course. This we have assured. But Lordship, what I pray is that there is only one line direction of plan. This is a very simple left-hand job for your Lordship. Give a direction, to inspect afresh and pass a fresh order. I have got all the papers with me.
Mr. Ganguly, no matter how much pep talk you may give about the powers of the court, we refuse to get excited and pass orders which are beyond our jurisdiction.
Lordship, I have to excite something. Sometime if I do not excite, sometimes initiate.
Heard Mr. Ravi Shankar Ganguly.
Lordship, you please, Lordship, I humbly submit to if I apply, let the portal be open. Portal is closed. How can I apply?
We will refer to that.
The direction of the Honorable Court says that you apply a fresh, but how can I apply? The portal is closed, and adjust my fee. Both the options are.
All right, you have argued your case to the best of your ability. We appreciate. Now allow the court to pass the order.
The thing is that there are two words, good and bad. If the last thing goes with me, then it is entirely bad. I am not a good submitter. I do not submit everything that is good. The bad prevails on the good.
Heard Mr. Ravi Shankar.
The bad prevails on the good. So whatever good I have, everything is bad if I fail.
heard Mr. Ravi Shankar Ganguly, learned advocate for the appellant, and Mr. Sunil Singh for the NCTE. The appellant institute had come up before this court against the order passed by the Eastern Regional Committee refusing to grant recognition to the institute for conducting DLED course, as also the decision of the appellate authority sustaining the decision of the NCET in not permitting in not giving recognition to the institute. On behalf of the appellant institute, it was argued that because of certain mishaps in the family, the matter could not be pursued further, and a request was made to the NCTE for postponing any decision making on the application made by the institute for recognition or revaluation of the decision refusing to give recognition to the institute. However, taking a different view of the matter, NCTE found that the management of the institute was not interested in pursuing the issue of recognition and closed the file. An year after the aforesaid closure of the proceedings before the ERC of NCTE, the appellant institute preferred the aforenoted writ application, namely CWJC number 7735 of 2020, which was rejected, the learned single judge rejected the prayer made therein, wide order dated 14/12/2020, but not without giving an opportunity to the appellant institute for approaching the NCTE afresh in case so desired, when the NCTE was expected to take a fresh decision in the matter. Mr. Ganguly, however, has argued that in anticipation of grant of recognition, necessary infrastructure upgradation was made in the institute, which already had been running for B.Ed course. The letter of postponement of proceeding, it has been urged, ought not to have been treated as representing the animus to have the proceedings postponed forever. Mr. Ganguly further contends that the institute would be satisfied, that the management of the institute would be satisfied if the fee which had already been paid by the institute for the purposes of recognition by NCTE is adjusted against any fresh application which shall be made by the institute for recognition for future sessions. Mr. Sunil Singh, learned counsel representing the NCTE, however, submits that with the closure of the proceedings, the fee stands forfeited in view of clause 5 of the rules of the NCTE.
Regulation
Clause 5
2014.
regulation. He further submits that under the new education policy, a new DLED course is on the anvil, and therefore the government of India has taken a decision not to give recognition to any institute in the interregnum, that is, before the new policy comes into play. Precisely for this reason, the national portal of the NCTE is not open for any fresh application to be made by institutes. Under the aforesaid circumstances, this court finds no justification to accede to the request made by the appellant for directing the NCTE to adjust the fee paid by the institute for consideration for grant of recognition. Stop. We, however, reiterate that in view of the new education policy and new course curriculum introduced under the policy, the petitioner institute shall be within its rights to apply for recognition, and if it does so, after fulfilling all the conditions, comma, no adverse view about the institute shall be taken by NCTE for the institute having failed in getting recognition
Lord, I must clarify
in the
one
past.
thing.
Yes.
That 4 years course, a portal has been opened, but this is exclusively for government institution. Only 50 colleges में ही ये लोग दे रहे हैं as a pilot project.
उसके बीच में और लिखना कि however it is clarified by Mr. Singh, Learned Counsel for the NCTE, that under the new policy, only 50 institutes as pilot institutes have been
Of central government and state government.
of the central and state government have been notified, and the petitioner institute and the appellant institute shall have to wait for the extension of such policy of recognition to other institutes. उसके बाद वही लिखते हैं. With the aforesaid observation, the appeal stands disposed of.